crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of XRP, has responded on the speculations suggesting that a resignation from Gensler is probable. Supporter of XRP and attorney John Deaton commented on reports that SEC Chairman Gary Gensler will be resigning. Deaton thinks it's likely that SEC Chair Gensler would retire for political reasons, even if news of his departure is still only a rumor. As a friend of the court, in the case between the SEC and Ripple, attorney John Deaton speculates that SEC Chair Gary Gensler may retire shortly. A rumor about the agency chair's position was circulating on crypto Twitter, and Deaton addressed it. Deaton claims that the SEC's recent crackdown on cryptocurrency exchanges and initiatives in the ecosystem may lead to Gensler's departure before of the forthcoming election. For nearly 2 years, the SEC has been involved in a legal struggle with Ripple, two of the main exchanges in the cryptocurrency ecosystem, Binance and Coinbase, have been sued by the banking regulator. Almost 600 cryptocurrencies were deemed securities by the regulator in the case, meaning the exchanges were facilitating the trading of unregistered securities. In the SEC's EVs, Ripple lawsuit, XRP investors are awaiting a ruling. According to Brad Garlinghouse, CEO of Ripple Labs, the summary decision in the matter from Judge Annalisa Torres is due in September. A verdict in the SEC EVs. Ripple litigation is expected by August 10, according to pro-XRP attorney Fred Rispoli. Rispoli figured this out by looking at the frequency with which Judge Torres issued summary decisions. At the time of this Monday's writing, the cryptocurrency was trading at 4,810 cents, having maintained above that level. Investors in XRP are keeping a close eye on the lawsuit and Ripple's future moves as the cryptocurrency continues its encouraging upward trajectory. A pro-XRP legal expert has provided further arguments in favor of the blockchain company's side of the legal struggle as the cryptocurrency sector excitedly awaits the outcome of the case launched by the United States Securities and Exchange Commission, CE, against Ripple. On July 2, attorney Bill Morgan asked in a tweet, if Ripple did anything nefarious or even illegal besides selling unregistered securities, why the regulator filed no injunction at all? He was part of a discussion that included prominent XRP community member, Mr. Huber, and former SEC enforcement lawyer Mark Fagel. What, he continued, was the purpose of safeguarding investors if, years after a case is filed, Ripple is free to pursue what the SEC deems to be obviously unlawful and detrimental acts to investors? For the protection of investors, shouldn't the SEC have at least considered filing for this? And he said the SEC would need to show how there is an investment contract when ODL customers who don't invest in the token and don't expect profits transacts the XRP within seconds for fast, cheap cross-border payments, not investments. According to him, Judge Phyllis J. Hamilton of the U.S. District Court for the Northern District of California has ruled in favor of a class of investors in the class action lawsuit Zakhanov. Lawsuit Zakhanov E's, Ripple Labs and C, marking a significant moment for SERP investors. The main claim is that Ripple is breaking the law by not registering XRP as a securities under federal and state regulations. A huge number of XRP buyers can now pursue securities lawsuits against Ripple, XRPU, and CEO Bradley Garlinghouse, according to this verdict. 2 months have passed since the last court date in the XRP investor class action lawsuit against Ripple. Bradley Sostek, the main plaintiff, filed a request to certify a class of all XRP holders worldwide who purchased, still hold, or sold XRP at a loss. Although defense counsel successfully argued for the action to be limited to us investors, despite Ripple's global presence, this order affirms the right of us investors to seek legal recourse. Judge Hamilton acknowledged the dynamic nature of the law as it relates to cryptocurrency. This ruling marks a significant step forward for the lead plaintiff and his legal team who allege a loss of $118,100 after selling XRP in 2018 due to Ripple's misleading claims regarding the token's security status, as she emphasized the need to allow individual jurisdictions to enforce their need to allow individual jurisdictions to enforce the cryptocurrency regulations. This paves the way for additional XRP investors to join the class action in an effort to recover their purported losses. Defense attorneys for Ripple and garlinghouse contended that class members' divergent opinions on whether or not XRP is a security would cause friction within the class. This argument was shot down by Judge Hamilton, who said that any issues could be settled using the usual opt-out method. Nick Spear of Sussman Godfrey was pleased with the court's judgment and excited about the next steps in the lawsuit. A representative for Ripple emphasized the significance of letting other nations regulate cryptocurrencies independently, citing the court's rejection of a worldwide class. As an example, the representative also confirmed that the court is prepared to wait for the conclusion of the XRP Ripple case before moving forward, while the industry waits for the result in the XRPs. Ripple Labs' legal dispute, a lawyer has speculated on when the verdict would be released based on the summary judgment ruling history of Judge Annalisa Torres. Attorney Fred Rispoli, who is on Ripple Labs' side in the continuing legal struggle with the U.S. Securities and Exchange Commission, has speculated that the court's verdict might be released in August. The attorney used data on the federal judge who is presiding over the case, Annalisa Torres of the United States District Court for the Southern District of New York, to emphasize that 60 of the judge's rulings came between 146 and 330 days, with the judgment announced in an average of 240 days. From these numbers, we may infer that the verdict was due on September 17, 2022. Or 249 days after the original move for summary judgment was filed, which would be May 21 this year. Since that month has passed without any word from court, that argument is no longer valid. Rispoli also considered using the 330-day criterion to the XRPs. Ripple Labs' case, which would likely result in a judgment by the court on August 10 of this year. Between 146 and 330 days, 60 of decisions are made. That's a total of 330 days or till August 10, 2023, or 249 days from September 17, 2022, which is May 2022, which is May 2023, which is May 2023. The attorney added after receiving what might be the finest or worst birthday present of his life. Which one of the two? John Deaton, another crypto law pioneer and pro-Ripple attorney, projected using data that Judge Torres' ruling may come out on September 6. Rispoli's prediction is somewhat earlier than Deaton's. Deaton based the September 6 deadline on the March 6 order by Judge Torres on the Daubert motion in the Ripple Labs complaint. In one case she issued a summary judgment ruling 6 months after ruling on Daubert. According to what Deaton mentioned during the broadcast, 6 months from her Daubert decision. If it were on March 6, it would be September 6. In May, Ripple Labs CEO Brad Garlinghouse said that the company believes the legal fight is coming to a close and that a ruling might be issued in weeks' time.